Imagine this. You're driving down a quiet street, minding your own limit, going under the speed limit actually, and out of nowhere, a parked car suddenly swings into your path. You hit her. The police show up, and somehow you end up listed as the one at fault. Your car is totaled. You're out over $700 in towing fees. And the other driver? She won't even pick up the phone to talk to her own insurance company. That's not a hypothetical. That's exactly what happened to one driver in Baltimore County, Maryland. And if you think this kind of situation is rare, you need to watch this entire video. Let's set the scene properly because the details here matter enormously. A driver is moving through a residential area in Baltimore County. She's going 26 miles per hour in a 30-mile-per-hour zone. That's important. She's not speeding. She's not distracted. She's just driving down a road the way you're supposed to drive down a road. There are cars parked along the side of the street. Again, totally normal urban driving scenario. Nothing unusual about any of this so far. Then, without any warning, without any turn signal, without any indication whatsoever, a parked vehicle suddenly pulls out and begins making a U-turn right into the lane of moving traffic. Our driver has no time to react. The collision happens almost instantly. Her car strikes the front passenger side of the other vehicle, and the other driver's door takes damage in the process. The physical evidence from the crash itself actually tells a story, and we'll come back to that in a moment, because it's more important than most people realize. Police arrive, a report gets filed, and here's where things start going sideways in a way that might surprise you. The police report describes the incident as our driver crashing into the side of a vehicle while it was making a U-turn. That single line of language, that framing, becomes the foundation on which her insurance company assigns her fault for the accident. 3 weeks go by. The other driver has not contacted her own insurance company even once, and our driver is now sitting with a totaled car, no collision coverage, and a $711 towing bill that came straight out of her pocket. She's frustrated, she's confused, and she wants to know, how is this her fault? That's the question we're going to answer today, and the answer is going to teach you something valuable, whether you're in Maryland or anywhere else in the country. Here's what most people don't understand about insurance fault determinations. They are not the same thing as legal fault, and they are absolutely not the final word. When an insurance adjuster looks at a claim, they're often working from limited information: the police report, photos, maybe a statement from one party if the other hasn't responded yet. In this case, the other driver had gone completely silent. That means the adjuster is essentially reading one document, a police report that uses language suggesting our driver ran into someone, and making a call based on that. But language is not law. And the way a police report describes a crash is not the same as a legal determination of who violated traffic code. That distinction matters enormously when you're fighting a fault decision. Now let's talk about Maryland law specifically, because this is a state with some very specific rules that are directly relevant here. Maryland follows what's called contributory negligence. This is one of only a handful of states, 4 states and Washington, D.C., that still use this doctrine. Under contributory negligence, if you are found even 1% at fault for an accident, you can be barred from recovering damages from the other party. That sounds brutal, and honestly, it is. It's one of the harshest fault standards in the entire country. But here's the flip side of that coin. It also means that fault determinations in Maryland carry enormous legal weight, and they are absolutely worth contesting with proper documentation and ideally legal representation. So, when our driver's insurance company says she's at fault, that's not just an administrative inconvenience. In Maryland, that finding could legally prevent her from recovering anything from the other driver's insurance, even though that driver pulled out of a parked position without signaling into active traffic. Let's talk about what the law actually says about U-turns, because this is where the case gets interesting. In Maryland, as in virtually every state, a driver who is executing a U-turn is required to yield to all oncoming traffic before completing that maneuver. The burden is on the turning driver. Full stop. You do not have the right of way when you are making a U-turn into a lane of moving traffic. You must wait until it is safe. You must signal, and you absolutely cannot pull out so quickly that an oncoming driver in a lane of travel has no time to respond. The physical evidence in this case actually supports that legal reality. Think about where the damage was. Our driver's car hit the front passenger side of the other vehicle. The other driver's door was damaged. What does that tell you about the geometry of the crash? It tells you that the other vehicle had pulled out and rotated into the lane. That car was moving into traffic when the collision occurred. If our driver had simply rear-ended a car that was already established in the lane, the damage patterns would look completely different. Crash reconstruction is a real thing, and the damage locations here are consistent with a vehicle that pulled out in front of traffic, not one that was simply sitting there getting hit from behind. This is the kind of detail that an attorney or an independent adjuster would seize on immediately. Damage patterns are evidence. They tell a story that witnesses and police reports sometimes get wrong. Now, the other driver not responding to her own insurance company for 3 weeks. This is actually a significant problem for the insurance process, but it may inadvertently help our driver's case. When a claimant or insured doesn't cooperate with their own insurer, that company can have difficulty completing their investigation. In some cases, if an at-fault driver refuses to cooperate, their insurance company may not be able to defend the claim properly. That's not a guaranteed outcome, but it does create leverage. Document everything. Keep records of every date, every phone call, every letter. So what can our driver actually do right now? Let's get specific, because this is the action section of the story, and it matters. First, request the complete claim file from her own insurance company. She has the right to see the documentation that was used to make the fault determination. Find out exactly what evidence they reviewed, what statements were taken, and whether the adjuster even had access to information about the other driver's failure to yield. Second, contest the fault determination in writing. This is not just a phone call. Put it in writing. Cite the specific Maryland traffic statute that requires a driver making a U-turn to yield to oncoming traffic. Include a written account of the damage locations and what they indicate about the dynamics of the crash. Ask the insurance company to reconsider based on this information. Third, consult a personal injury attorney. Many work on contingency, meaning no upfront cost. Given that Maryland's contributory negligence standard is at play here, having an attorney who knows the state's traffic laws and can push back on the fault finding could make the difference between recovering nothing and recovering the full value of that car, plus the towing costs. Fourth, if the other driver's insurance eventually does engage, file a claim there directly and be prepared to dispute the liability finding. Do not accept an initial denial as the final answer. Fifth, consider filing a complaint with the Maryland Insurance Administration if the insurer is acting in bad faith or refusing to properly investigate. State insurance regulators exist precisely for situations like this. The bigger lesson here is one that every driver needs to hear before they ever find themselves in this situation. A police report is not a court verdict. An insurance company's fault determination is not legally binding. Both of those things can be wrong, and both of those things can be challenged. The language in a report, the way something is framed by an officer who arrived after the fact and reconstructed events without any dashcam footage, can paint a picture that doesn't match reality. And insurance adjusters working from that single document with one party not cooperating can make calls that simply aren't accurate. If you are the kind of driver who goes under the speed limit, signals every turn, and still ends up getting blamed because someone pulled into your path without warning, you are not helpless. You have rights. You have recourse. But you have to advocate for yourself, and you have to do it with documentation, persistence, and ideally someone in your corner who knows the law. If this happened to you, if an insurance company blamed you for an accident you know wasn't your fault, just accept it. Get the file, contest it in writing, talk to an attorney, and keep every receipt, every note, every date and time of every conversation, because that paper trail is your best weapon. If you found this video useful, subscribe to this channel. We cover real insurance situations, the confusing, the frustrating, and the ones where knowing just a little bit more makes all the difference. Hit that notification bell so you never miss one.